Good morning, good evening, good afternoon. I think I'm live. I don't know if I'm live. You never know if you're live. StreamYard says I'm live. Says I've been live for 20 seconds. Oh, there we go. All right. So just so that everybody's in the know who is in the know, this weekend I got tired of not having a dog. Technically, I have my sister's ancient pit bull, Kenzie. Came to me as a sausage at like 13 years old. Now is 15 years old, has a nice sleek coat, looks like a dog again. Got tired of it. I have a beautiful video of a gray fox that is just roaming around my fenced in area where I've got the chickens. And can't have that. So we adopted, my wife and I adopted this dog right here, Zumafu. Probably gonna change the name. Mastiff, apparently, something from the Placer County Animal Shelter. So yeah, so I have a new dog. For those of you who don't know, there was, in theory, going to be a interview today. I was going to interview RSN, the DMCA lawyer, Randall Scott Newman. He even agreed to it, but it turns out he's a giant flapping vagina. So he decided not to do it. So here we are. Hard to interview someone who's just a giant flapping vagina, and the only sounds they can make are queef noises. So anyway, yeah, there you go. So for everybody who's looking for an attorney, just remember that he's a bit too much of a bitch to show up with in person or with the camera on him. So I mean, I've never yet met an attorney who was scared of being on camera. Well, let me rephrase that. I guess there's lots of people who claim to be attorneys who don't show up on cameras, but mostly attorneys, like, they're okay. I mean, they speak in public all the time. They are on hearings, like various courts that I've been in have had the hearings streamed. So, for example, because I'm a first-year family law attorney, there's a DCSS department in Sacramento that always streams their hearings, and you could watch it even if you're not in the case. So, like, I'm sure hundreds or thousands of people would have seen me in action at this point, as it were, action, not in the porn sense. Anyway, so on to the subject of today's video. So this right here is an honor your oath video. He's added in the comment section. The link to the videos in the comment section. I'm not trying to steal his ad revenue. We probably won't get through the entire thing, but I have had countless. Well, I guess I could count them if I really cared to. So it's not really like that version of countless, but I've had people DM me about this particular deposition. I had a guy come into my Discord server just to get me to watch this video, and then he shit the bed. So that happens sometimes. I've had people in the comment section bring it up. I mean, I've had emails about this. I mean, my email's out there, so it's not unsurprising, but it's just amazing. It's just amazing to me the amount of interest this deposition has generated. And the description given to me by the gentleman who showed up in my Discord didn't make it seem like it was that interesting at all. It sounds like it's just a normal deposition with a savvy deponent. But people think it's super exciting and amazing, and everybody is so incredibly upset by what this cop did that they can't believe it. Before I click play, though, I just want to remind everybody. because this is an honor your oath video. Well, and people have also said in the comments, if you scroll up, that there's already been a settlement. And I think the guy in Discord also said that there was a settlement, and it settled fairly shortly after this deposition. By the way, we still haven't eaten the rooster. My wife named him Big Ben. He probably won't get eaten for a minute or two. Depositions are rarely crucial for anything. When you're deposing someone, they are a hostile witness. They don't have to review anything prior to showing up. They don't have to remember anything. It is, in fact, common. I, generally speaking, advise my clients not to review any materials before showing up, because if you don't remember, you don't remember. And if they ask you if there's anything that you can, or you say I don't know, is what you say. You say I don't know. You don't say I don't recall, because then they'd ask you to refresh your recollection. But if they ask you if there's something that you could review to refresh your recollection, you say again, I don't know. Because remember, my rules that aren't mine, that I've inherited from someone, there's 5 rules. Number 1, if you could answer yes or no, answer yes or no. Wait, hold on. I screwed it up already. The first rule, let's do them in order. First rule is count to 5. Slowly in your head before you answer any question, every question. If they ask you, what's your name, you count to 5 slowly in your head, and then you give your name. You always give the attorney who's defending you the opportunity to think about the question that's been asked and to interpose any appropriate objections. Number 2 is if you could answer yes or no, you answer yes or no, and then you shut up. A lot of times attorneys don't realize that they should follow up on a yes or no question. So, for example, if they say, is it true that you punched Bobby? You just say yes. You don't defend yourself. You don't say, well, Bobby was coming at me with a knife. You just say yes. They might not know. They might not have all the correct information. And it's really not your job as the deponent to give them the information. That's not your job. Your job is to answer all their questions, but not to give them information. Rule number 3, there are some questions that you can't answer yes or no. Like, what year were you born? Well, you can't answer that yes or no. So you think about it. You take as long as you need to think about it so that you could answer the question in 1 sentence or less. If you just can say like 1 word to answer it that's not yes or no, do that. Like, what color is your car? You can just say purple, right? Whatever. But you always want to answer it 1 question or 1 sentence or less. The 4th rule is, if you don't know, if you don't remember anything else, if you don't know, you say, I don't know, then you shut up. You stop talking. You don't try to give them further information. You just say, I don't know. If they ask you another question that you don't know the answer to, you just say, I don't know. And you keep repeating, I don't know, until they exhaust themselves of questions, or your attorney interposes some objection that gets them redirected. And the fifth and final rule is always tell the truth. Always tell the truth. It's not worth it to lie in a deposition. Now there's if someone asked me what was the date of your law school graduation, I would say, I don't know. Right? Is that a lie? No, it's not a lie. I could probably figure it out, but I don't know. If they asked me what year it was, well, I could probably get a lot closer at that point and tell you the year I graduated. But the thing is, like, it's just saying I don't know. Like, if you're unsure about something, you can say I don't know. One other niggling little detail is you never guess. You never guess. Never guess. If someone asks you for an estimate, like if they say, if you're sitting at a table, a lot of times depositions happen at a conference table. If someone asks you, how long is this table? You can estimate. You can say, well, I don't know exactly, but I would estimate it's 12 feet long. But typically I counsel my clients, you don't give an estimate unless you're specifically asked to give an estimate. If they say, how long is this table, and you don't know exactly, you say, I don't know. And you call that at the end of the day. But then if they ask you to estimate, then sure, you could say, well, I would estimate it's this much or whatever. All right, so now we're going to actually start this. I am drinking water for those of you who are wondering, with a little bit of lemon in it, lemon juice. I don't plan on drinking anything. I don't really feel great, and I do have court in the morning, so here we go.
You ready? Great. Please raise your right hand to be sworn. Do you solemnly swear that the testimony you're about to give and the following cause to be the truth, the whole truth, and nothing but the truth?
Good morning, Sergeant JOFFRION. My name is Reed Marks. I'm here to take your deposition today. Would you begin by giving us your full name?
Joseph JOFFRION.
You don't have a middle name?
No, sir.
Okay. And I'm gonna hand you a pad, and I'd ask you to put your name, your address, and phone number on this. The reason I'm not doing it on the record is because I expect that this deposition will end up being filed with the court, and as such, it would be publicly available. I don't want you to get doxxed. So would you mind?
Why would you file a deposition at the court? You might indicate that it would be, well, I guess if you used it as part of as at trial, sure, then it could theoretically become part of the record. I would suspect, knowing that this is honor your oath, I would suspect that that this is getting recorded for the sole purpose of being published by honor your oath. But that's fine,
Writing your name, address, and phone number.
So, Michelle, most deponents, when they're getting deposed, come across as smug and irritated. That is par for the course. They're a hostile witness. They don't want to be there. You're not their attorney. You're opposing counsel's or your opposing party's attorney. That is what happens. They are a hostile witness. They're being called by opposing counsel. They're hostile. That's duh. And most likely, if JOFFRION gets called, he will most likely get called by his counsel. So the jury will have an opportunity to make their own opinion of him before honor your oath's attorney gets to go in there and make him look bad and ask him the questions that he doesn't like. I'm going to speed this up a little bit. Southerners talk slow. I also talk slow, and I'm not Southern, but...
And we're reserving all objections that performed to the record.
Wait, hold on a second.
We're reserving all.
That sounded like an objection as to the form. Hold on a second.
And we're reserving all objections that performed to the record.
That's a bold strategy, Cotton. So there's several kinds of objection, and basically he says the only kind of objection he's going to make is an objection to the form, meaning the form of the question. So if it's a malformed question, leading wouldn't really count in this case because he's a hostile witness, and you could lead hostile witnesses. Maybe not in Mississippi, I don't know. Generally speaking, you could lead hostile witnesses. If the question is phrase is argumentative, no, that's not form. If it's vague and ambiguous, I guess. If it assumes facts not previously not previously. Why am I blanking on this? Facts not in evidence, but if it assumes facts that are not already previously established at the deposition. Or if it's compound, I mean, there's different objections that you can make to the form. The substance of the question would be something entirely different, like if it's irrelevant. So basically, this really, dude. So basically, this cop's attorney is saying that he's not going to object to the substance of the question. So if it's not relevant, if it calls for speculation, if it's presumably he's not going to intersperse a geez Louise, ladies, they don't respect me at all in my own house. So sorry about that. I was reading something. So that's a bold strategy. I don't know how it's going to play out for him, but I wouldn't have done that. Reserve on objections other than as to form. Well, so in California, if you don't object to the form of the question at the deposition, then you may lose the objection. Yes. So the school of depositions that I come from is based on California depositions, and in theory, you should object to everything you can object to because you may waive it, and theoretically, technically, the deponent still has to answer theoretically and technically all questions except unless there is an assertion of privilege. If you assert privilege, then they don't have to answer it. I have in the past done, and I've seen other attorneys do, counsel their clients not to answer certain questions based on objections, not on privilege. And there's not a lot that the deposition attorney can do, the deposing attorney can do, other than to, in the future, bring a motion to compel a response to that objection. I have never seen a motion for motion to compel further testimony filed, let alone granted. So it is not entirely unsafe. And because see, the thing is, like, if it's a valid objection, if it's a real good objection that they shouldn't answer the question, then opposing counsel goes in there and says, Your Honor, he improperly counseled his client not to answer the question, and it wasn't based on privilege. But then the court's going to look at it and be like, well, what was the question? Well, why would he answer? Obviously, why did I just blank on that word? The objection. Obviously, the objection is a good objection, so I'm not going to make him answer that just so it can be objected to later, right? Standing objection, no. There is no such thing as a standing objection. You have to object to each and every one. So there's some discussion about coming up on this in my Discord. If you do want to come up, there is a link. The only issue is that you must show your face. You can't be a giant pussy. You got to show your face. So we got 10 acres. And I swear to God, if I'm sitting out here, roosters have to be within like 5 feet of me to crow. 10 acres, and they're crowing at my foot.
You put your number on there. I can't. It's upside down.
No, we'll ask, will any of this information get released out to public?
No, that's why I'm asking you to write it on a separate sheet of paper.
Okay.
Let me make clear, what are we doing with is this being recorded, or is this just for your client's ability to view the deposition?
Oh,
So is this recording, you plan to put this on the internet or something?
no, I'm not planning to put it anywhere, but I'm recording it because I'm also.
Yeah, it's a Weasley response. Obviously, he's planning on giving it to his client. His client's going to put it somewhere. He's weaseling.
Videotaping it, and the rules allow me to do so.
Because my thing is, I've been threatened.
Just stop. Do you have the notice that was filed?
I do not.
Do you have the notice?
I do.
The notice probably has to say in California, if you're going to video record a deposition, the notice has to state that you're going to video record the deposition. But in California, you also have to have, at least under California state law, I'm not talking federal law. I don't know if this is a federal or state case, but in the state deposition rules, you have to notify them, and there has to be a someone who's not your employee, like not the employee of the attorney who's doing the deposition, who actually does the video recording. So,
But more importantly, let me just point out the local rule says that I can record this.
so there's a local rule that says you can record it. Oh, awesome. Depositions are open to the public. They're not public record necessarily. They don't normally get filed anywhere unless you use them at trial, and then a copy would be lodged with the court and would become part of the record for an appeal, which means that in theory, unless it's sealed, then it could be public record at some point in time. Yeah, thanks, Eddie. He already said it was a local rule that allowed him to do it, so I don't need to discuss that anymore. But thank you. Is this paused?
Yeah, I mean, I don't have any objection to obviously it being recorded, but just for everybody's benefit on here, if somebody's planning to release this or put it on the internet or something like that, then, we're going to file a undue publicity motion. So, a motion for a protective order. So I just
Undue publicity motion. Well, good luck on that, chuckle fuck.
want to be clear and put everybody on notice of that, but go ahead.
This is riveting so far. This is about every deposition I've been in so far.
Have you used any other phone number since this incident with Mr. Gray, other than the one that you just wrote down? All right, Sergeant JOFFRION, I think you know what we're here about. Have you reviewed the body cam footage that was obtained during your interaction with Mr. Gray?
Yes.
When was the last time that you reviewed that?
Yesterday.
So would you say that you're comfortable with the contents of that video, or do you need to see it again to refresh your recollection?
Objection vague is to comfortable.
I'm good.
Now, during that interaction, you made a statement that Mr. Gray didn't need to explain anything to you because I literally don't care. Do you remember saying that?
Correct.
And then you further stated, I'm here in reference to a complaint by the mayor of this city. Is that correct?
Correct.
And at whose request were you there? The name of the person?
Say that again.
You said, that I'm here in reference to a complaint by the mayor of this city.
Okay.
Who is that?
JJ Frank, the mayor.
And did he call you directly to make that complaint?
No.
So how were you there in reference to a complaint by the mayor? How did that get routed to you?
Objection vague. What do you mean by how does it get routed to you? You would only know how he received it, right?
Just find out a little bit better.
The mayor.
So the problem is by waiving all of these objections, or not by waiving them, by reserving all these objections other than as to the form, the attorney's not actively participating. Normally you have a time frame that this deposition has to get done in, and the time frame has to include all of the objections made by the attorney. And so if as an attorney, and I'm not saying this is what every attorney does. This is how I was trained to do it by other attorneys, by an other attorney. And it seems to work well for me. If I don't understand the question, before I let my client answer it, I'm going to object and say it's vague and ambiguous. I don't understand what you're asking for, because I want to know where the DMCA lawyer is. I don't know, Thailand, I guess. But I want to know what the question is, so that I can at least object to it. If I don't know what the question is, I don't know if I can or should object to it. And if I don't know what the question is, then my client probably also doesn't know what the question is. So if he answers it, what question is he answering? You don't know. I don't know. He probably doesn't know. Your client probably doesn't know. So I just object to it. I try to be very active in the deposition. I try to wear down the deposing attorney, because, I think he wishes he was, probably, but that's just from my understanding of his love of ladyboys.
Didn't call you.
Yeah.
You showed up with Mr. Gray and said that you're here in reference to complaint by the mayor. Connect those dots for me. How did his complaint that wasn't made to you get routed to you so that you were the one responding?
Objection, compound question. Like, how many questions are you going to ask before you actually get an answer from the deponent, sir?
Investigator Eddie Hersey.
And by the way, one fun thing is it's always better to object more, even if some of your objections are unfounded, than less, because again, part of this is just tactically to slow things down. It's to run out the clock. It's to frustrate the other attorney. It's to give your client more time to think. It's to maybe make the other attorney, like, if you could argue an objection with an attorney for like 5 minutes, he might forget what the question was.
Called me.
So normally I don't like to dox my clients. There was one deposition that I did where the deponent actually called the police on me, and she was old, so she was talking loud enough and she had her phone loud enough that the court reporter could take down everything that was being said to the dispatcher. That was pretty fun. I may see if I could find that and redact it down and post it somewhere. It was just transcribed. I'm not a big fan of the video depositions normally, generally speaking. But I guess, like, if that's your thing.
Called you on what device?
Cell phone.
This cell phone number that you gave me?
Correct.
And what internet provider is this?
AT&T.
Is this a personal device?
Yes.
So, I'm sorry, what did you say Mr. Hersey's title was?
Investigator, chief investigator.
Is this sped up?
The Waveland Police Department Chief Investigator, Mr. Hersey, called you on your personal cell phone to do what? What did he say?
He said
To do what? What did he say? Well, that's two different questions. Pick one and stick with it, counsel.
email was harassing the clerks inside of the city hall, peeping through windows, and then went outside and stood on the sidewalk.
Is it standard for you to?
By the way, I'm not on the cop side. I'm sure. So from my knowledge of Jeff Gray, just so that we're all on the same page, from my knowledge of Jeff Gray, he's got a very good style to him. He, generally speaking, is within the bounds of the law. He isn't a peeper. He doesn't harass people. He's not a panhandler. What else do they? He's most likely not trespassing. He stays in public areas. This was some sort of a public building, but he stays outside on things that at least resemble public sidewalks. So I'm going to assume that this guy screwed the pooch. I'm going to assume that. I'm not on his side. I'm just I don't know, trying to find some way to make a deposition entertaining by interspersing objections for the apparently absent defense counsel. Because why would he actively defend his client? Why would he? It's enough just to show up and take a paycheck, I guess.
To receive calls, dispatch instructions on a personal cell phone?
Yes, that happens.
How often does that happen?
I couldn't tell you.
Would you?
Objection vague. Objection vague. How often does that happen? Objection vague. How often does it happen to my client? How often does it happen in Waveland, Mississippi? How often does it happen in the world at large? How often? Indeed. How often? How often does it happen? Who knows? How about you ask him a specific question?
You be able to say whether it's more often than not?
Back to the form.
I just want to say, everybody, welcome Aaron Queen. He always gets one post per video, and I love him for it. I treasure him. I look forward to timing him out. Thank you for participating, Aaron. You, sir, are an amazing person, and I appreciate your patience with me. He always comes back for more. I think he's a little bit gay for me, and don't get it twisted, Nate. Me and Aaron, we're not a couple. You still got a shot, Nasty. You still got a shot.
So you don't know if it's more or less than 50%.
Here and there, depending on situations. Sometimes.
Why would?
See, so you don't know if it's more or less than 50%. Yes. That would be the correct answer. He's already talking too much. JOFFRION is cagey. He understands that sustained. He understands that this attorney, even though this attorney is coming on all folksy, is not his friend, and he's being very cagey. He's just talking too much. Yes, no, I don't know. Yes, no, I don't know.
Would Chief Investigator Percy call you on your personal cell phone for police business?
You would have to ask him.
Objection. Calls for speculation. Like, why don't you depose the inspector? Why don't you, or investigator, whatever the hell, Hersey? Why don't you ask him these questions? Why are you asking my client what somebody else thinks, believes, knows? How about you limit your line of inquiry to what my client actually knows?
Do you make police business or police related phone calls from your personal cell phone?
As far as what?
Anything having to do with your connection and your employment with the Waveland Police Department?
Objection, vague, overbroad. Anything connected to it, like what? So if I call a fellow cop who also happens to be employed there on the weekend, to see if he wants to come over and have a beer, that's in any way related to my employment, right? Because it's a coworker. Ooh. What if I call my girlfriend and tell her, hey, I've got tomorrow off. Do you want to go and watch a movie? Well, that's related to it. So that's definitely vague and overbroad. How about you tighten it up, counsel?
Department. Do you make those calls from your personal cell phone?
Yes, by a different phone number.
What's
What?
the different phone number?
See, he should have just said yes. He should have just said yes. Now we're looking at a different phone number. Apparently, dude has a different phone number. Previously, he testified he only had one phone number. See, why didn't he just say yes? Why didn't he just say yes?
There's some kind of police app that I use. If I call follow up with something. I'm not even sure the number. It's auto-generated.
That was a lot of information.
What's the name of the app?
1021.
And so your testimony is that phone number changes?
Mhm.
I'm sorry, you need a yes.
Yes.
How do you know this? How does he know this? Does he know it? Does he know it? I don't know. Does he know it?
And you make those calls through the app on your personal cell phone.
Correct.
If someone calls back the number that appears as the outgoing number, if you call someone using this app and it has a randomly generated number and someone calls that back, does that?
Objection. You're speculating it's randomly generated. No one's here to testify whether or not this number is randomly generated.
Get routed to you?
I'm not sure. I've never had anybody call me back.
Maybe you've never had anybody call you back because it's not the same number every time and it doesn't go back to the app.
So I'm going to go back to a previous question. I asked you if you'd used any different phone number. And while you may not have had a different mobile account, your testimony is now that you've used many different phone numbers in your employment.
Objection asked and answered. You're not here to testify. He's already testified as to this. Let's move along, counsel.
How would we get a list of those phone numbers that you have used?
I have no idea.
Good answer.
Is this app 1021 a subscription?
I'm not sure.
How did you get this app 1021?
Downloaded it.
Did you have to create an account?
It's been so long ago, I don't recall.
How long have you been using this app?
5+ years.
See, if you just answered yes, this is a whole line of questioning that we wouldn't have gone down. Whole line of questioning, we wouldn't have gone down if you just answered yes to that one question.
Is this something that the Waveland Police Department knows you use?
No.
It's not something they encourage you to use then?
No.
To your knowledge, does anyone else use this app?
Yes.
Is it common?
Objection.
What is what comes?
Objection calls for speculation. Vague. Is like, what do you mean? Is it common? Is the 1021 app commonly used by police officers in the Waveland, Mississippi Police Department? Is an entirely different question. Is the use of apps generally to call people common in the United States of America or the world? So how about you ask a fucking question, counsel?
Is it common among the Waveland Police Department?
I don't know.
Well, who do you know that uses this app?
I don't know either. I just know it was recommended.
By whom?
I don't know. Officers in the past.
See, he keeps giving extra information. I don't know. Officers in the past. Just shut up after I don't know. I don't know. Period. Stop. Breathe.
That I came in contact with.
At the Waveland Police Department or somewhere else?
I'm unsure.
How long have you been employed at the Waveland Police Department?
Somewhere around 3 years. Before then, another agency. Before then,
No, you say I don't know. You say I don't know. You say I don't know. Would you have an estimate? Yeah, I would estimate I have worked at the Waveland Police Department for 5 years. Why is he talking about other agencies? Why is he talking about other agencies? This guy's a horrible deponent. He was not coached well at all.
Waveland again.
But here's a fun fact. Every deponent I've ever had, maybe with one exception, has been a horrible deponent. Every single one. You coach them. Here's your five rules. And they're like, you got the 5 rules. And they say, yeah. And you say, okay, we're going to role play a little bit. I'm going to pretend like I'm opposing counsel and I'm going to start asking you questions. And it's not going to be nice, right? I'm opposing counsel. You're going to use the 5 rules. And they're going to be like, okay. And I'm going to say, all right. Raise your right hand and repeat it after me. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? They say, I do. I say, okay. What's your name? And they say, my name Jeff. Like right away. And you're like, no, dude, no. And then you get like, no, you got to wait 5 seconds. You got to like over and over and over again. You just got to beat them up over it. And then like you get into the heart, like into the contested part of the issues, the heated stuff. Like, you know, like, and you start asking them the questions that you would ask them if you were opposing counsel. And they start trying to justify things. You're like, no, you just say yes, no, I don't know. You don't do that. You don't do that. If I need you to clarify at trial, I will have you clarify. But now is not the time. There's nothing you could tell opposing counsel. There's literally nothing you could tell him that's going to make him turn to his client and say, you know what, we should just drop this. There's nothing that you could do that will do that. So you say yes, no, I don't know. Anything else is 1 sentence or less. You take your time before you answer every single question. You don't guess. You only give an estimate if you're asked for an estimate. I mean, you just, and if after you say yes or no, you shut the fuck up. I'd have been kicking the shit out of this dude's shins. I don't care if he's a cop. I'd have been kicking his shins left, right, and center if I was his defense attorney. And I'd probably be saying like, my client needs to take a break. Apparently he just shit himself.
So total 7-8 years in law enforcement, if I can recall correctly. Not 100% positive. How long did it take?
So now you've given him license essentially to go down 7 or 8 years of agencies that don't have anything to do with the Waveland, Mississippi Police Department that are completely irrelevant. Like, why did you do this, dude? You dug your own grave. This is a 2-hour deposition, 2 hour and 27 minutes apparently, and it's a 2 hour and 27 minute deposition because you didn't answer questions well. And ultimately goes back to your attorney's fault.
You worked with Waveland twice. What was the other agency?
Harrison County Sheriff's Office.
Approximately how long did you work for the sheriff's department?
I'm not sure.
In the aggregate, how long have you worked at Waveland Police Department?
I'm not sure.
Okay. All right. So he's doing good there because he could have estimated and he didn't.
But you believe approximately 7 to 8 years total of law enforcement experience.
Correct.
Did you go to a law enforcement academy?
Correct.
Where?
Harrison County,
Do you know what year?
2018.
Do you know what year? The answer to that question is yes. You'd be surprised at how many times I trip up my clients when I'm trying to get them ready for a deposition. I'll say, do you know your birthday? And they'll say, October 2nd of 2022. And you're like, what happened on October 2nd of 2022? Like, is that your birthday? Why'd you say yes? Why didn't you say yes? Why didn't you say yes? Oh, way over, way over. Way over. Just the amount of fat that hangs over a belt is over 240 pounds. The training that I got for doing depositions was primarily from an attorney who I first started working with when I first became an attorney, who has currently 50 plus years of experience. And he loves depositions. He does depositions for pretty much every case. Like, he loves depositions. He uses them for a variety of reasons. I guess I can go into this. So the first reason that he uses depositions is, number one, it gives his client the impression that he's in charge. Because remember, I told you that unless opposing counsel asserts a privilege, the deponent still has to answer. And most attorneys are just going to let their client answer. And on non-serious objections, like, objection relevance, you let him answer. So basically what he gets to do is he gets to perform for his client, and he'll tell the client ahead of time, by the time they leave, they're not going to have fun. They're not going to like me. I won't raise my voice. I won't swear at them, but they're not going to have any fun. And I'm going to show them that I'm going to be in charge in the courtroom. Well, the deposition isn't in a courtroom. But it does appear, if you don't understand, it does appear that he's in control, because even opposing counsel will be like, no, you got to answer his question. Yeah, we don't want to answer it, sure, but you got to answer the question. So that's the first thing. The performative aspect of it is a big deal. The second thing that is the big deal is it's really good to get a settlement. Now, I'm not saying it's going to be really good to get a settlement for, like, if you're suing a cop, because cops get deposed a lot, I would assume. Cops get sued a lot. Cops probably get deposed a lot. Cops have probably been in more depositions than you care to imagine. Plus, they're witnesses a lot of times for certain situations, like car crashes and things like that, where they respond to the scene. So cops are going to get deposed a fair bit. They're going to be your savvier deponents, but a lot of people don't like to have to answer questions. A lot of people don't like that sense of powerlessness, where the person who's supposed to protect them, the attorney who's supposed to protect them, is basically not protecting them at all. They still have to answer all these questions. There are no Matlock moments in a deposition. It's just question after question after question after question after question for seemingly endlessly, right? So they don't like it, and so they tend to be more ready. They tend to be readier to settle after a deposition. it lets them know that they won't probably have fun on the stand, because all these questions are not much fun to answer, and some of them feel like they're a bit incriminating. And I'm not talking about criminal. There's not usually a lot of depositions in criminal. Depositions are very rare in criminal. I'm talking about in civil matters, but people don't really understand the difference. They feel like they're getting incriminated with these questions. They feel like, you know, I don't want to tell you that I was actually watching YouTube videos while I was driving down the road and rear-ended you. I don't want to tell you that, but my attorney's telling me I have to. So those are the two big reasons. It is also a form of discovery where you can kind of cut it down to the heart of the matter. Usually, so for written discovery, like interrogatories and requests for admissions and things like that, a lot of times those take months and months and months and months and months, because you got to first send out the request for discovery. They get 30-ish days to respond, less in the federal side of things. And then within a certain amount of time, you've got to bring your motion to compel. You have to make good faith efforts to resolve disputes. And they know this, and opposing counsel knows this. And so like getting answers, getting actual answers in like interrogatories can take literally like 3, 4, 5 months to get them done. And if you have to file a motion, if they push to the point where you actually have to file a motion to compel further responses or to compel responses, period, you know, that hearing, that motion hearing might be a couple months out itself. You know, and then they respond, and maybe they don't even fully respond then. It just could be a long process. And depositions, usually you get your answer right then and there. So there are advantages to depositions. Now, my preferred style, having seen him do his thing, is typically I will do written discovery first. You know, you don't, generally speaking, at least in the counties where I'm in, you don't go to trial within, you know, a year of the start, maybe even 2 years of when it was filed, right? So you've got a lot of time to get discovery done. So usually I go down the written discovery path, and then if I think I can benefit from a deposition, I will do a deposition. So are paralegals essentials or even involved? I don't use paralegals. I don't, generally speaking, see other attorneys use paralegals. Usually it's attorney, co-counsel, and deponent. Usually paralegals, they're not really a thing. At least I've never really experienced them much.
You said that you watched the body cam footage yesterday. Having reviewed that within the last 24 hours, is there anything that you thought you could have done better?
I think I object to the form.
Objection, Peg? Oh my God.
No, hold on. What's the objection?
Oh, there was an objection. Finally.
Having reviewed that within the last 24 hours, is there anything that you thought you could have done better?
I think I object.
So objection, thought you could have done better what? At the stop? Thought you could have done better reviewing the video? Thought you could have done better sleeping last night? How about you actually ask a full and complete question with all the requisite details, subject, verb, pronoun, you know, whatever. Like give me a real question, not a vague question. So I'd object vague. So let's see if I'm right. Let's see if we get a good vague objection.
Object to the form.
What's the objection?
I would object to the point. What the fuck is that? I'd object to the point. I'd like to object. Well, first of all, your client already answered, so it's a little bit late there, Sparky. But what the fuck does object to the point mean?
You can object.
No, hold on. What's the objection?
You're asking him to speculate.
No, I'm not asking you to speculate.
If you're comfortable with the question, then let him answer.
No,
I'm gonna object to, I think if I don't agree with the question, then I'm gonna object to the form. And if you're not, well, you stand on the question. If you're not, you can.
Objection calls for speculation. I don't know that that's an objection to the form question, but make your objection. Stand up to him. Chest out, sir. 10 toes down.
Phrase it. That's how this works.
No, I'm entitled to know the basis for the objection as to the form. You said all objections, except as to the form of the question, are reserved. And now when I asked you for the basis of your objection, you said it's asking him to speculate. That's reserved. That's not in the form of the question. So what's the
So that is not form.
objection to the form of the question?
you're asking the question that I think is.
See, this is where he fucked himself. Like I don't understand. I don't know. It was form, Michelle, FORM, the form of the question. I don't understand why he reserved on all of his objections other than to the form. Like I don't. That doesn't like that was a bad call. Bad call, Mr. Attorney. You thought you were going to get to snooze through this, and now maybe you realize that you were fucking retarded, and you should feel bad.
Requiring him to stipulate. If you're comfortable with the question, he should continue to answer the question.
Go ahead and answer the question.
Repeat the question.
Is there anything that you think you could have done better?
I could have handled it a little different.
Objection, vague, ambiguous. Done better as to what?
How?
See, that's a form. That's actually a form issue. Vague. Like, what the fuck are you asking him, dude? That's form.
Reworded something.
A lot. So in normal conversation, people say very vague things, and the person on the other side hears the vague thing, interprets it in the context of the situation, develops it into an actual coherent question, and then answers the coherent question that they've kind of built in their head based on everything. And for normal conversation, that works. That's absolutely appropriate. It totally works. In this circumstance, in a deposition circumstance, it doesn't work. It doesn't work, first of all, if you're the deposing attorney, you want to have a good, clean question. Because if it does have to get used, if you do want to try to get that introduced at trial, you don't want to have to go back 3 pages to try to build the context of what the fuck the question was you were asking. You want the question to be the question, right? You want the question to have all the necessary elements in it so that the judge can know, or the jury, as the case may be, what you are asking, and so that the judge and the jury knows that the person responding, the deponent, they know the question you're asking. If you ask a vague question and they give you a response, are they responding to the question that you thought you asked? The answer to that might surprise you. I can't tell you the number of times. I am a very specific person, but people still interpret the things that I say in their heads when I'm talking to them. When I'm in lawyer mode, I'm very specific. And I can't tell you the number of times where clients have interpreted or reinterpreted the question, like depositions. People reinterpret them all the time. So I'm just saying that you want to be really fucking clear when you're asking the question, and you want to be really fucking clear what the question is so that you could object to it if you're the defense attorney. If you're the deponent, I mean, the sloppier the question, the better it is, because how can anybody say that he perjured himself? How can anybody say that? If it's a shit question, you can't say he perjured himself.
Thanks.
I'm under the impression from the comments that this guy perjures himself somewhere in here. We'll see.
What things?
I can't recall off the top of my head.
Do you need to watch the video again?
No, I don't.
So if your testimony is that you could have reworded some things, but you don't know what things,
I know what things.
what things?
Just handled it better. Talked a little different.
How?
I don't know. I'm not.
I know what things. That's kind of. I don't know what he's trying to communicate there. He's being cagey. I know what things, but I can't tell you specifically what things.
In their shoes right now.
Well, part of this is we have the benefit of hindsight.
It might be, I could have handled things better because I got sued over it, and apparently there's some merit to it. And for those people who think that auditors never get settlements, well, apparently there's a settlement in this case. So congratulations to Jeff. You done fucked up, Sergeant JOFFRION, whatever. And sometimes for all of you anti-frauditors, sometimes the cop fucks up. I don't know. So can someone in the audience tell me if Jeff was arrested on this one? I don't know. I don't know what specific one this is referring to. It'd be interesting if he was arrested from it, because all the anti-frauders would be like, ha ha, Jeff Gray got arrested. And I'd be like, well, ha ha, he wasn't supposed to be. and now Joffrion and or Waveland, Mississippi is paying the price for that horrible mistake.
We also had the benefit of having reviewed what happened. I don't know how many times you watched the video. At least
Oh, boo. Jeff was not arrested. Well, boo.
once.
Not that I want Jeff to be arrested, but getting arrested would increase the settlement. It would really hammer home even further the bad policing that's being done. And that son is going to kill me. So I'm going to remove myself. I'm going to be back in 2 shakes of a lamb's tail. All right. Let's see. Put my ears back in. Sorry to disappoint you, WTT. I am coming back. Unlike RSN, I'm not scared to be on camera.
But other than rewording some things, and you can't say which things, you can't tell me anything that you would have done differently or done better.
Objection asked and answered.
Same objection.
Same objection. Same objection. Same objection. Oh, this defense counsel is going to irritate the living shit out of me.
Well, I have to think on that.
Well, how can you say that there are things you would have done, but I can't answer the question as to what they would have been?
I just know I could have
Objection argumentative.
handled it better, but it will give me time to think on it.
So did you make any mistakes?
I would have done the same objection. Vague. Make mistakes when? What do you mean by mistake? Objection, vague, ambiguous. I know some attorneys. I know if an attorney's watching this, they're probably like, "You motherfucker, you wouldn't do that." Yeah, I would, and it frustrates the ever living piss out of opposing counsel because I look them dead in the eye, like I'm serious, and I say objection. Like I'm going to object every goddamn time. If you don't ask a clean question, I am objecting every time, all the time, and we're going to have a fight about this for like 10 minutes each time, every time.
This is a different question, but
Dan, we covered this. California also has objections only as to the form. You can actually make all of your objections technically, but they still have to answer. But the thing is, what are they going to do? Are they going to bring a motion? I don't think so. I mean, I guess if you push it too far, they may. But no, like I'm objecting the fuck out of everything. I don't give a shit. What are they going to do? What are you going to do? I'm going to ruin your fucking deposition, dude. If you can't ask a clean question, then you're going to have a shitty time deposing my client.
similar. Do you deny making any mistakes?
Object to the form.
Rewrote the question form.
Do you deny making any mistakes in your interaction with Mr. Gray?
Same objection.
His attorney is like same objection. Same objection. Say the objection again. Say it again. Objection calls for speculation. Objection calls for speculation. Why don't you just actually object instead of saying same objection? You lazy cuss.
You're asking the same thing, you know, we rephrase it.
It's not the same thing. Do you deny making any mistakes with Mr. Gray?
Objection asked and answered.
I'm not getting what you're saying. Have to break it down for me.
You should have just said, I don't know.
My first question was, do you admit to making any mistakes? And you answered that in the negative. Now my question is phrased differently.
So you admit, counsel, you admit it's asked and answered. So let's move along.
Do you deny making any mistakes?
I did not make any mistakes.
And you can have both of those two things be true at the same time. You could say, I should have done things differently, but I didn't make a mistake, because the word mistake, as I objected to earlier, is vague. What do you mean by a mistake? You know, is it a mistake that I ended up getting sued in federal court? No, it's not a mistake. They did it on purpose.
Tell me what the elements of vagrancy are.
Tell me what the elements of vagrancy are. Say, I don't know, dude. Say, I don't know.
I can't.
Tell me what the elements of vagrancy are.
Object to the form. What objection, dude? What objection?
I can't
Just attorney just ignores him at this point, which he should.
think off the top of my head right now. I'm not.
Because if this, I know it's not going to, but if it did go to trial and they did try to introduce this objection to the form, that's not an objection. That's not an objection. He just flapped his lips. He didn't say anything.
Tell me what you recall. Tell me what you recall.
Tell me what you recall. Okay.
Are the elements of the crime of vagrancy.
Say, I don't know.
I can't recall. I don't know the laws by heart.
So he's saying I can't recall. I can't recall is different. I can't recall is different than I don't know, because you may have never known. You may have never known what they are. And so, you know, Alpha Fox Adam is saying, you know, dude is an attorney. I don't think they're calling for contention stuff. Because like a lot of times, like you can't like in an interrogatory, you could ask them about like legal things, you know, things that call for a legal conclusion. I don't think necessarily that would really apply on this one, because he is a police officer. And did he well, he didn't arrest Jeff Gray, so I don't know exactly why vagrancy is at issue. I'm assuming he either arrested Jeff Gray for vagrancy or he threatened to arrest him for vagrancy. But I also want to remind my audience that cops can lie. They can lie, and they do lie. And if he just wanted Jeff to move on, he didn't want to arrest Jeff, then why wouldn't he lie about having him up for vagrancy?
I just know what certain crimes are. I'm not aware.
So what is the crime of vagrancy?
I can't say it verbatim.
I'm not asking for verbatim. I'm asking you to tell me. You said you just know what the laws are. What is the
Objection asked and answered.
Certain crimes are. I'm not aware.
He says, I just know what certain crimes are. I'm not a lawyer.
So what is the crime of vagrancy?
Well, he didn't say he knew what vagrancy was, did he? So again, I would have objected as his attorney. Objection asked and answered repeatedly. This is argumentative. You're badgering my witness. Stop. Next question.
I can't say it verbatim.
I'm not asking for verbatim. I'm asking you to tell me. You said you just know what the laws are. What is the crime of vagrancy?
Objection. This is like the 5th time you've asked this. Asked and answered. Badgering. I am now instructing my client not to answer. So can we move on now? I mean, if you want to bring a motion to compel my client to answer this, great. But he's already told you like 5 times he doesn't know the answer. So how about we move along?
Can't answer that right now.
I don't know. So I understand that the cop is supposed to be the bad guy, but I'm telling you that defense counsel is the bad guy. Defense counsel is the one who let his client in here completely unprepared. Defense counsel is the guy who's not making all the appropriate objection. Like even inappropriate objections.
On top of my head.
Well, you accused Mr. Gray of vagrancy the moment you stepped out of your cruiser. What were you accusing him of doing?
Okay, we got an attorney in here, boys. Dan Fizzle, attorney at law. Hey, Dan Fizzle, how about you come up here, show your face, and we can have a discussion about why the elements of the crimes are relevant to this cop who didn't fucking arrest anybody, you douche canoe. Why are you trying to play attorney? Why the fuck are you trying to play an attorney? You don't know what the fuck you're talking about. He wasn't arrested. He wasn't arrested. You didn't need to know the crimes. You didn't need to know the elements of the crimes to not arrest somebody for it. You dumb fuck. Jesus. I'm so smart. I Googled. I didn't know the right question to Google, but I Googled. I got it wrong anyway.
Harassing customers.
So is vagrancy harassing?
I didn't mention that to him.
I didn't ask that. Is vagrancy harassing? Is that what you think?
Objection. This is like you're still trying to develop the elements of the crime. How about you move along?
Crime of vagrancy is? So what is the crime of vagrancy?
Why is defense counsel asleep at the wheel? Defense counsel needs to be drug out back and shot. Defense counsel needs to be drug out back and shot.
You can't think of it off the top of my head right now.
You don't know what the crime of vagrancy is.
If I had the statute in front of me, I could then tell you.
Are you aware that the statute had been repealed 5
Oh.
years?
Wait a minute. You are not banned. I have never banned you from Discord. I have never banned you from Discord. Discord. Open Discord in your browser. What the hell's at Chardboy at Chard. You're not in my Discord anymore. All I did was remove your, how am I spelling this right? Charbo. You must have left. Where do I go to? Users? No, not user settings. It's not user settings. You right click on the thing, server settings, and then bans, server settings, bans. And we're going to do Charb. There's no Charbo. No Charbo. You're a liar, sir. You are a liar, Charbo. Charbo. Nope. See, like, I am me. There you are. Charbo. Nope. You're a liar. You know what that means, Charbo? You know what that means? Time out. Don't lie. God doesn't like liars, Charbo.
Before you accuse Mr. Gray of vagrancy? All right, so how did he commit the crime of vagrancy? How could he possibly have committed a crime that had been repealed 5 years ago that you can't even define?
I'm object to the argumentative nature of these questions. I would ask you to calm down a little bit when you're asking questions.
Oh, hold on a second. No, look. Charbo is here. Look at that. He just said, I'm here. He literally just said, I'm here. So who banned you, Charbo? Who banned you? No one. You lying little twat. Sorry about that.
I didn't arrest him or identify him off of vagrancy.
Do we need to watch the video?
If you want to watch it, you can. I'm not.
Well, let's watch the beginning of the video. Up to this point that we're talking about with vagrancy.
Let's not watch the video. How about that? I guess if you want to eat up your deposition time by playing a video, that's great. My client doesn't have to watch it though. And also, you know, Charbo, if you want to show your face, you can come up here and tell me how I'm wrong and I actually did ban you or whatever the fuck you wanted to say.
That was you speaking, correct?
Sure.
And he asked you why you needed to see identification, and you said
I couldn't hear anything. Hold on a second. I guess there was something.
Identify him off of vacancy.
do we need to watch the video?
If you want to watch it, you can. I'm not.
There you go. Good boy.
Well, let's watch the beginning of the video. Up to this point that we're talking about with vagrancy.
I can't hear that. I can't hear that. Must have been an earthquake in Waveland,
That was you
Mississippi.
speaking, correct?
Sure.
And he asked you why you needed to see identification, and you said vagrancy.
Okay.
All right. So what is vagrancy?
So what is vagrancy? Objection vague. If you are asking what the elements are, again, for like the 20 billionth time, this is definitely argumentative. Stop.
I'm not a lawyer.
But you are a law enforcement officer. Was this
But you are a law enforcement officer, yeah, but he doesn't know what the elements of the crime of vagrancy are. And you didn't arrest anybody for the crime of vagrancy. So
dispatched by Chief Investigator Hersey for harassing and peeping through windows?
Correct.
And not the first, but near the first word out of your mouth is vagrancy, which we've already established is a crime.
I don't know. Say I don't know. I don't know. There you go. Good boy. Who would know? I don't know. You could say, I don't know. Saying I can't answer that doesn't actually tell them that you don't know. Say, I don't know next time. Charbo, you're a retard. You're a retard. Quit messaging me. Quit messaging me. The link is pinned to the top of chat. If you're too fucking stupid to figure out how to get in here, then there's nothing I could do to help you, Charbo. There's literally nothing I could do to help you. Dummy. Oh, I'm sorry. I did a bad. Present. Share screen. Boomer. Boomer alert. All right.
And not the first, but near the first word out of your mouth is vagrancy, which we've already established is a crime that was repealed 5 years earlier. So I'm trying to
not
understand
sleeping with you,
why
Gail.
you approached Mr. Gray, who's standing there holding a sign, and accused him of vagrancy.
How did I accuse him of it?
He asked why you would need identification, and you responded vagrancy. Do we need to play this again?
You can play it.
Do you need to see it again to know that that's what
I don't
happened?
need to say anything.
So
You can't, again, like, so the cop is like, yeah, I did accuse him of bankruptcy. Great. Congratulations. I was trying to get him to identify. Obviously, that's what the cop was trying to do. You know it. I know it. The guy asking the questions knows it. The deal is that the attorney really wants the cop to say, I lied. That's what the attorney really wants the cop to say. Like that, duh. And guess what the cop's not going to say? The cop's not going to say I lied. Why would he say that? Once he says he lies, that anything you say can be used against you. Now that can be used against the cop if the cop says he lied. So the safest course of action for the cop is to say, I don't know. I don't know. I don't know.
You did accuse him of vagrancy.
I didn't use some of the
So why would you say the word vagrancy?
I guess Charbo still can't figure it out. God, if you're this fucking dumb, bro, maybe it's not smart for you to come up. Maybe it's not smart. Yeah, no one cares about you, dude. Literally no one cares about you.
I don't know.
Well, who would know?
This is where he should say I don't know again, but he doesn't. I think we're caught up to where
Can't answer that.
Did you respond that you had received several complaints that Mr. Gray was begging for food, money, stuff like that?
if that's in the video, then that's in the video. Like, why are you asking him about things that are in the video? Like, is this really what we want to do? Like, the video speaks for itself. He says in the video what he says in the video. Why don't you ask him a real question?
You had not personally observed Mr. Gray begging for food, money, or anything of the sort, had you?
Never.
Who had you received a complaint from that he was begging for food, money, and stuff like that?
Investigator Hendley.
That would be, I don't know.
Well, you said you got several complaints that he was begging, but you don't know who any of the several complaints are.
I didn't receive any complaints that he was begging for money.
Where did you get the information? I'm sorry. Where did you get the information that there had been several complaints that he was begging for food, money, and stuff like that?
Top of my head.
So you hadn't received several complaints.
I have received several complaints.
So then
that
who
he was
made?
harassing people.
But that's not what we're talking about, not harassing. You said several complaints, begging for food, money, stuff like that. Who were the several complainants?
Who knows? I don't know.
So what was your basis of your...
Again, the attorney really wants him to say I lied, and he's not going to say he lied. See, I you know what? Some people don't deserve my time and attention. I don't know why people think this is so amazing. It maybe there's a point in it somewhere where this gets amazing, but it hasn't gotten amazing yet.
Your statement that there were several complaints, he was begging for food, money, and stuff like that.
Harassing customers.
What customers?
I'm not sure. Whatever's listed on the report and the statements we have.
There's not any name on here besides the ones that we've talked about.
Okay.
So there's your name, Investigator Hersey, and Mayor. There's no complaint. Who is the complainant that he was begging for food, money, and stuff like that?
You should have statements. Complaints on them.
What would those statements look like?
Witness statements, complaints.
Well, who made a witness statement? I don't have one.
Well, so if like there should have been disclosures. There should have been disclosures if someone actually made a complaint. I know JOFFRION is talking like there is, but well, I mean maybe there's a fuck up somewhere, but there should have been. This is federal. You have to disclose everything, kind of like at the get-go. So they should have disclosed everything, like all of the calls, the 911 calls, all the complaints, all that fun stuff, witness statements, all that stuff should have been disclosed. So once he knew, so here's the thing, once the attorney knew that JOFFRION was just marching to essentially the dispatch from Hersey, then it's like, ask Hersey. Like, that's where you go to find out who the complainant was. You ask Hersey. Where did Hersey get that information? Because Hersey is essentially dispatched JOFFRION. At least that's what I'm picking up. Maybe I'm wrong.
I don't know.
So I see Charbo is backstage, but you got to show your face. You got to show your face. Same rules every time, all the time, Charbo. You want to come up and get talked to like you're a retard, you got to show your face. Take your lumps.
So you said to Mr. Gray that you had received several complaints that he was begging for food money, stuff like that. And he responded, that's not true. And you said, well, I'm just out here for that reason. And again, asked for identification. I need a yes.
Yes.
And he asked you whether he was required to provide identification. And you responded that he was. And he asked, if I don't, what will happen? And you said, you're going to jail, period. Do you
Yes.
recall saying that?
Yes.
All right. So what were you going to take Mr. Gray to jail for if he did not provide you identification?
Nothing. I was just trying to bully him into giving up his ID. But he's not going to say that because that would mean he lied.
To comply.
Failure
to comply. See, he should have just said something along the lines of, I don't know, because now he threw failure to comply out there. And I'm just going to guess that unless he had, well, I don't know, is Mississippi, do they require ID on reasonable suspicion, or do they require ID on probable cause, or what? I mean, so maybe we'll see.
comply with what?
But if it's reasonable suspicion, maybe failure to comply would work. If it's probable cause, then all of a sudden now you're going to go down the road of he's going to ask you about all the elements of problem or of failure to comply, yada yada yada. Like you should have just said, I don't know. There's a reason. There's a literal reason why we have the 5 rules. There's a literal reason why. It's no fun to depose someone who knows the 5 rules. It's just not fun. You don't have a good time doing it because all you get back is yes, no, I don't know. It's purple, whatever. You know, you have to work to get your information. Basically, you have to know the information you're trying to get, and that's all the information you're trying to get. So I do remember there was one deposition I was sitting in on. I wasn't the attorney actually taking the deposition. I was merely there because the attorney taking the deposition liked to have another attorney there just in case, is there a question I need to ask that I didn't ask at the end of the deposition? Anyway, the deponent, his attorney had coached him very well. And he did the yes, no, I don't know. And he also had a book with him, like a little journal book. And every time the deposing attorney would ask him a question, he'd make a mark of some sort in that book. Don't know what he was writing, but he would just make a mark. He would just make a mark. So the deposing attorney would ask a question, he'd make a mark, and then he'd say yes, no, I don't know. Oh my God. It threw the deposing attorney completely off his game. He was obsessed with what's in that book. And so like he starts demanding the book. And you know, you haven't demanded this in your deposition, deuces taken. We've responded with all the documents in your deposition, deuces taken. This isn't it. And like it completely, that was, like I said, this guy's been doing it for like 50 plus years and he loves depositions, and it just wrecked him. Like he looked like a fool walking out of there. He didn't get to impress his client. The other attorney was a hero. The deposed party came out of there a winner. He knew that. So normally it's the opponent who goes out of these things feeling terrible. This time it was the attorney asking the question who walked out feeling like he lost. So it was a win. The five rules are amazingly productive. And apparently, yeah, if you draw tiny dicks into a journal while you're getting deposed, I mean, it just drove that attorney crazy.
With a lawful order.
And what was the lawful order?
Identification.
See, now he's going down a long road of stupid. You can't just order someone to provide identification. You don't have reasonable suspicion of failure to provide identification until you've asked for it, and you can't demand it. You don't have a lawful order to demand it until there's at least reasonable suspicion, if not probable cause, depending on the state. California, you don't have to give your name until booking, if that. So yeah.
Under what circumstances are you entitled to demand identification from a person?
Reasonable suspicion of conflict.
So what I would recommend you do is you sit there for a few seconds, at least count to 5, maybe wait a little bit longer, and then say, I don't understand the question. If you think it's vague, just say, I don't understand it. Can you rephrase it? Because I don't understand what you're asking for. But again, usually for the deponent's sake, a vague question is fine, because especially if you're trying to obfuscate, you give a vague answer to a vague question and nobody will know. And you could tell your attorney about it later. But I would say, like, if you really think it's a problem and the question is vague, you might want to, well, I don't know. See, I don't want to get involved in between you and your attorney. Your attorney might not be objecting to it because your attorney might want to obfuscate. So if you're the client, play the client. Don't play the attorney while you're playing the client. How about that?
All right. And what reasonable suspicion?
But if you don't understand a question, you probably ought to say something along the lines of, I don't understand the question.
Did you have that he had committed a crime?
Harassing customers, peeping through windows, repeatedly asking people for money.
But you just told me
Oh, hold on a second.
Hold on a second. Single person.
I don't know.
Hold on a second. We've got add to stage, and we're going to go. All right.
Can you hear me?
What do you want to say? Unfortunately,
I can't
what do
hear
wanna
you.
say?
I don't know. Did you say anything?
Did I? You tell me.
I can't hear if you're speaking.
No, that's too bad. I think everybody else can hear. So
Hello?
boomers.
Know their names
Well, who did you speak to? Where did you interact with these persons?
beforehand? I didn't.
All right. So how did you have a reasonably articulable suspicion that he had committed a crime if you had not spoken to one single person?
Oh, no one can hear what's going on. God dang it. All right. So just out of curiosity, can everybody hear me? If you guys can't hear me, if Charbo's the retard, then there you go. Can you hear me? I think it's a 1 in chat. Okay, so everybody can hear me except for Charbo, and I'm not gonna do tech support for Charbo.
You just told me that you're not aware of one single person.
I don't know their names
Well, who did you speak to? Where did you interact with these persons?
beforehand. I didn't.
All right. So how did you have
Again, these are all terribly asked questions, and he should just be saying yes, no, I don't know.
a reasonably articulable suspicion that he had committed a crime if you had not spoken to one single person? Can't identify.
Yeah, I could hear Charbo. I could hear Charbo, and you guys could hear me. So I don't know. I don't know what his problem is. Well, problems are.
One single complainant and had no personal knowledge of anything.
He's back. All right, can you hear me, Charbo?
I can hear you. Can you hear me?
Oh yeah, I could hear you.
Okay.
What do you-
How's it going?
What
How's
do
it
you
going,
need
man?
to say?
How's
What
it
do you
going?
need to say? What do you
I
need
don't
to
really,
say?
you wanted to talk to me. I mean, I brought this video to your Discord because I wanted your perspective. I respect you as an attorney. Okay.
Oh, don't guess.
Wait,
Me.
let me just tell you one thing. You told me it wasn't worth your time.
It's not.
Okay, well, why are you making a video on it then?
So I am doing a stream because I had scheduled this time to talk to God, what the fuck is his name? RSN, the DMCA lawyer. So this stream was initially scheduled for that.
Okay.
And so he bailed out because he's a giant fucking pussy. And I'm like, well, gee, I've already talked to my family and I have this time. What am I going to do in here? Now,
The DMCA lawyer, is that the guy in like Estonia, the bald guy? I think I know who you're talking about.
I don't know if he's bald or not. He's in
He does
Thailand. He's
copyright
getting
law.
railed by ladyboys.
He does copyright law on YouTube. I don't know. It doesn't matter. I mean,
He's doing DMA's lawsuit.
all right. So I don't know. I mean, I thought the video was interesting. I thought
So why is it what in it is interesting? Because I haven't obviously been interested in anything other than the
The
bad
same thing
lawyering.
that caused everyone, on Reddit and on other YouTubers to cover it. The cop is just
I
embarrassing.
haven't watched them.
Okay, but the cop is just embarrassing. He just said, I can't recall to every question. And I know you said that that's what you're supposed to do in a
That's what you're
deposition.
supposed to do. Yeah. So
I
he's doing what he's supposed to do.
I understand that. But don't you think it's problematic for our public employees to act like this in a deposition? And I know he's doing what he thinks in his best interest. And to some of the questions that he answers in this way,
Why don't you ask me one question at a time?
Okay, you're fair. The one question I remember is the lawyer asked him what the policies are, and he just go, I don't recall. And then he said, well, where would I go to find out? I don't recall. Like those questions, you can't answer that way. I mean,
Why not?
and I'm not a lawyer. That's blatantly perjuring yourself. And that's just one example. Like we could go through the whole thing. We're not going to do that, but I thought it was ridiculous. That was what made me bring it to your Discord. I respect you as an attorney. I watch your videos.
What is on your birth certificate? What county is listed as your mother's father's date of birth, or mother's father's county of birth?
My mother's father's?
Yeah, your maternal grandfather. What county is listed as his date of birth?
In Connecticut.
What county is listed as his place of birth?
Connecticut. I think New Haven. I don't know.
You don't know? You don't
New
know?
Haven County? Why?
Well, I mean, this is your birth certificate. Don't you think that your birth certificate?
Where I was born, or where my mother?
Let me answer. Don't you think that your birth certificate is more personal and has more important information to you than a policy generally, or a list of policies generally?
I'm giving you the answer that I know, and my best estimation it would be New Haven County. That's
you don't know.
No, I don't know for certain because I've never seen it with my own eyes. I've never seen that document.
Right. And so if he starts saying what policies are, then what is the lawyer going to do?
But it'd be said.
Just answer the question before you ask another question.
I understand your point. I understand your point.
What? Just tell me what the lawyer's going to do, so I know you understand my point. What's the lawyer going to do?
Can you repeat? What's the lawyer going to do if he says what? What was the question again?
If he starts identifying what he thinks
Is
about
the
the policies, what he thinks about them, because remember they're not in front of him. If the lawyer starts asking him about that stuff, and he gives an answer about what he thinks, what is the lawyer going to do?
And then he gets it wrong. And okay,
what's the lawyer going to do?
I don't know. You tell me. I don't know.
The lawyer's going to follow up and start asking him more and more detailed information. Now, if the lawyer wants the information about the policies for the police department, don't you think the lawyer can get those policies from the police department?
Yeah, of course.
He doesn't need that cop to tell him about it. The only reason why he's asking that cop about it is to trap him on minutia.
Is to further his case and to show that he doesn't know the policies. He is a supervisor, though. I feel like he should know those policies to some degree. Now, obviously not verbatim. He should be able to recite
questioned on
some of the. You could say. So what happens if he doesn't get it right? What is the consequence if he doesn't answer the question correctly verbatim? I don't understand the consequence.
I'm just going to go out on a limb. I haven't read the lawsuit, but I'm going to guess that there's a Monell claim that's also involved on this lawsuit. Anytime you sue a cop,
as far as I know, the lawsuit was settled. As far as I know.
Well, let me finish explaining before you butt in further. So I am going to assume that there was a Monell claim. Are you familiar with what a Monell claim is?
I kind of know. It's a
yes
civil rights claim. I don't know exactly. It's a civil rights claim.
So let me tell you what it is.
Refresh my memory, please.
Let me tell you what it is. A Monell claim is where you sue the city for failure to train, for policies that they have that are discriminatory in some way, etc. So what the attorney is doing at this point is he already has the policies. If there was something, this is my best guess. So, again, this is all grain of salt. I haven't read the lawsuit, but he's got the policies. So what he's going to do is he's going to look to see if there's going to be a discrepancy between what this JOFFRION guy is, who you say is responsible for some of these policies, and the policies themselves, to try to establish that there is a as applied issue with the policies because it's not readily apparent with the as written policies. It's literally a trap that he would be walking into if he just half-assed said, well, it might be X, Y, or Z. And if he doesn't know, and what he should do is he should shut the fuck up. Don't you think you have an obligation to tell the police and to help society by telling the police everything you know as soon as they come and ask you a question?
Do I think you have an obligation to tell the police everything you know and ask you a question?
Wouldn't society be better if everybody just told the police everything as soon as they asked a question?
I, in some ways it would be better. In some ways it would be worse, and that's the straightest answer I can give you. In ways it would be better. It would be better. The police could do their job better, yes. But if the public was forced to answer questions that the police asked them, I mean, that's not the way our society is like set up. Like the laws are set up, and that would, allow the government to encroach on freedoms like ridiculously if you had to answer their questions. I mean, don't you agree?
Well, so your point is essentially that society would be better if our public officials like JOFFRION would just pony up all the information they have on the top of their head at the word go. Except you don't want to apply that same logic necessarily. You're willing to give some of it to citizens, but not all of it. I would say for society, it probably would be better if citizens would just tell everything they had at the drop of a hat. But I will tell every single citizen, shut the fuck up, don't talk to the police until you have a lawyer present.
I agree with you completely on that. Yes, shut the fuck up and invoke your rights. I would give everyone the same advice.
So JOFFRION, you say the same thing. Shut the fuck up.
I think
yes, no, I don't know.
Legally, he's doing the right thing by not talking.
Okay.
He couldn't, instead of saying I don't recall, why can't he just say I invoke and I refuse to answer? Why can't he do that?
Because it's not a Fifth Amendment issue. He's not going to go to jail for not knowing the policy.
Yeah. With the Monell claim, isn't that, not that you have to, but you go that route when you can't get through their qualified immunity? That's when you have to go to the department?
No, Monell claim is generally an additional claim that gets thrown on, usually just because you want the deepest pockets possible. And especially if the city doesn't fund these lawsuits, or county or whatever, then the cop might not have a lot of money. He might be judgment proof. He might only have X amount in his insurance policy. The city's going to have more money. So you want the city to be on the hook. So you want to be able to sue the city. Does that make sense?
So, yeah, that makes sense. So why if you want to sue the city, why isn't every claim a Monell claim? Like,
well, so
towards a police officer.
Because generally speaking, you can't sue the city out of the gate.
Right. You have to prove that they train their officer in a incorrect way in order to sue the department in the city, right?
Or they have a policy that requires it. Monell claims have to be tacked on to a 1983 lawsuit against the person.
Okay. I agree with you that legally the cop was doing the right thing by not answering questions. I'm not disputing that. Just the way
he's in a lawsuit. So the only thing that matters is legally, because he's in a lawsuit.
Yeah.
If you walked up to the counter and you said, hey, Sergeant Joffrey, thanks for helping me out today. I would like a copy of all the policies for the police department. He should provide them to you. He should provide them to you, right?
Right.
But that's a different situation. And if you said, hey, Sergeant Joffrey, buddy, I'm looking at this policy and I don't understand it. Can you explain it to me? He probably should explain it to you if he's responsible for the policies for the department, but not in a lawsuit.
Right. I agree with you on this, that legally he should be doing everything he can to protect himself in this lawsuit. That's just the facts. But the way he conducted himself, the way he just doesn't care, the way he's just, I don't recall. It's just, it doesn't rub you the wrong way to see a public.
Every deponent ever. That's it. Because if you don't want to be there and you have some asshole on the other side asking you all sorts of questions that you don't want to answer.
How much longer is this going to take?
Oh my God. How much longer is this going to take?
You know how he cannot be there is by not doing the shit the way what he did, just do his job correctly.
Sure. Hindsight's 2020. Congratulations, Charbo. You figured it out.
I did.
Any other words of advice for us?
No, I gave that one example of the I don't recall. You're deflecting it well. You're an attorney.
I haven't seen anything where, how far are we at in this thing? We
Well,
are
I mean,
almost a half hour into this thing. And the only thing that I really can object to is the way
it
defense
gets worse.
counsel is doing it.
It gets worse as it goes along, in my opinion.
Are you just saying his attitude? No one cares about his attitude.
That's a part of it. The way he shows
Oh.
contempt for the whole process, the way he thinks.
He's not showing contempt for the process. He's showing contempt for the person who's asking him the questions.
I disagree. I disagree there. He shows.
Give me a timestamp.
I don't have the video memorized. I mean, I've watched it a couple times.
Oh, you've watched it a couple times? Well,
Yeah.
come on, Charbo. Why don't you answer? Why are you trying to dodge these questions?
You got me.
Isn't that crazy how it's fine if you do it, but not him? Isn't that weird? Crazy.
Well,
All
no
right,
one could give you a timestamp. That's ridiculous.
No one can give me a timestamp of a specific spot. You've watched
Now,
it a couple
unless
times.
I wrote it down.
You've watched it a couple times. So just like Sergeant Joffrey can't give specific examples, even though he watched the video in the morning, you can't do it.
Well, he lived it too. It's
Well,
not just a
he
video.
lived it.
Yeah.
When's the last time you watched this video?
Watch the video.
Yeah,
The video.
video
I watched
review today.
probably when I was in your Discord the other day, like 2-3 days ago,
3 days ago.
4 or 5 days ago. I don't know.
And how long was it from the time that he lived it? Like he lives these things. I would assume that him being this kind of cop probably lives these things like 4 or 5 times a day. Normally, and the difference between Jeff Gray, who looks like he's a homeless person, and the normal recipient of this behavior from Joffrey or JOFFRION, whatever the fuck, is that the homeless people normally don't sue. They normally get bullied and leave.
Well, they
The
can't.
only difference between
They don't have the financial means.
So
get
that
what you're
day for this sergeant is Monday. It's not anything special. It's a fucking Monday for him.
Yeah.
Why is he going to remember it? Why is he going to remember this particular homeless person who he wasn't able to run off as opposed
He's not, but he should remember it because of his behavior. But you're right. He acts like this all the time. And
of
that's part of the issue.
Yeah. But
So
what
wait,
do you
let's not talk
want?
about the deposition. Have you watched the video of Jeff Gray didn't get arrested, but did you watch the interaction?
I've seen a lot of Jeff Gray videos.
I
And
know, but
normally
did you see this? Did you see this?
normally the cops walk up lying about bullshit, because every time I watch one of the videos, every time I've done a video on it, I'm like, yeah, cops can fucking lie. And they lie all the time.
Right.
There's nothing wrong legally with them lying. They can lie to you. They lie to you all the time.
Right. They legally lie to you.
So if they can lie to you to resolve the issue, get you to move on, get the people who are bitching about homeless people begging out in front of their building, then why wouldn't they do it? Because there's zero problem with it.
Well, I never said the problem was him lying in that interaction. That wasn't the issue. I mean,
And
the issue was
there's also no problem. There's also no problem with him going up and demanding information.
Well,
If
in my
arrest,
opinion, he did not have reasonable articulable suspicion. That's my opinion.
No one gives a shit about your opinion. He didn't need
I didn't
reasonable.
say you had to give a shit. I mean, that's just what my opinion was. Well,
See, you're arguing the wrong things. You flap your lips.
Did you
flap
watch?
your lips?
Did you watch
flap
the
your lips.
interaction?
You flap your lips instead of listening, because you don't know shit about fuck. He doesn't need reasonable articulable suspicion unless he detains somebody. Now, if
He
you
did
detain
detain
Jeff Gray,
You detained him. What are you
we
talking
haven't
about?
got there yet. You can't expect me to be omniscient.
I asked you if you watched the video, and then you won't
I
even
don't
answer
fucking
the
care
answer.
about your interpretation.
What?
I don't care about your
So,
interpretation.
did you watch the
But
video or not? Yes or no? Like, what the hell?
I have not watched a video. How about you shut the fuck up for a few seconds? I'm gonna help you just for a few seconds. I'm gonna help you shut up. So, in order to demand ID, the cop doesn't need shit. He could just walk up and demand ID. Now, if he wants to get you in trouble for it, if he detains you for it, well, then all of a sudden, now that he's escalated it, now he actually needs, depending on why he's detaining you, he needs reasonable suspicion at that point. But just to demand your ID, any cop can walk up to you at any time, at any place, and say, "Give me your ID," and demand it. Now, it's whether or not you get in trouble for not giving it to him that's going to be the issue. Now, I will unmute you.
Okay, he did detain him in this interaction.
Yes. If you didn't eat breakfast this morning, how would you feel right now?
I don't eat breakfast ever. I'm not a breakfast person.
I thought so. Well, I appreciate you coming up. We're going to get back into it. Thanks for joining me.
about begging for food or vagrancy?
Objection. No question. I did have information that he was expecting for money and harassing customers
What information?
from what investigator actually told me.
And is that phone call recorded anywhere?
No, it's not.
You don't know what device?
He should have said, instead of no, it's not, he should have said, I don't know. Because all he would know is he didn't record it, but is it recorded anywhere? I don't know. I mean, does AT&T record them, etc.?
He called you on, but you received the call on a personal cell phone. Correct. And those calls, are they recorded?
I'm not, my profession isn't telecoms.
Or do you know if on your end?
No, he can demand it. He can demand it. It's whether or not he actually escalates it to a situation where you're detained or arrested. That's when things get spicy. He can demand. Cops can demand. But can they enforce? That's the difference, Rogue. You're not understanding words.
And the phone call was recorded.
No, it's not.
And you had, from Investigator Hersey, you weren't provided any names. Did you have any details about the people that Mr. Gray was supposedly harassing?
No.
All right. So the crime that you were investigating at that point was harassment?
Correct.
Harassment, correct? Should have said, I don't know. I'm investigating a call, is what he should have said.
In your criminal case report, this is dates labeled defendant 15 and 16.
Bill, I don't know that I'm going to get through 2 hours of this. This is another deposition. This is not anything interesting. This is just a deposition. Like, I don't understand what, maybe it's because I do this and I've been into a lot of others, a lot of depositions that, like, I see this, like, nothing in here has been shocking. No, absolutely not. Nope.
Well, let me first provide you a copy of that. Is that your report?
Yes.
You prepared that?
Yes.
In that report, under crime description and code section, we have 97-3-107, stalking following.
No. Well, maybe. So you get to play a fun little game I like to call guess what the cop knows. If the cop comes up and demands ID, you get to play the game of guess what the cop knows. If the cop has facts, which he does not have to tell you, because remember, cops can lie. And it just amazes me that auditors always forget that cops can lie and say that they have reasonable suspicion when they don't, but they could also lie but lie by omission and fail to tell you when they believe they have reasonable suspicion. And you, Rogue Nation, will never know if they have a reasonable suspicion unless and until you get in front of a judge, because the judge will say whether or not they had reasonable suspicion. And the cop will never know if he had reasonable suspicion unless and until he gets in front of the judge, because it's the judge who determines whether or not he had reasonable suspicion. So you get to play a guessing game. So what I would normally recommend, if you're not an auditor and you don't want to play the guessing game, I would normally recommend that you just give them your ID. That's what I would normally recommend. But you can play the game. I mean, you could play the game and the cop can continue to lie to you, and you don't know if he's lying to you or not until your windows end up broken, or not windows end up broken, but until you end up in cuffs, right? Cops can lie in order to circumvent your rights. Cops can lie to convince you to surrender your rights. They don't circumvent them. If the cop lies to you and says you have to show me your ID or I'll arrest you, well, you get to play the game of either you show him your ID, and if he couldn't have arrested you, well, then he got you to surrender your right by giving you the ID. Yeah. So, yeah, I don't know why this is groundbreaking news for you. you. You've lost enough of these lawsuits that you should figure this out.
And harassing, threatening.
Yes.
What are the elements of that crime?
Objection. Calls for a legal conclusion.
I don't know. I'm not a lawyer. I would have to look at the state statute.
Did you look at the state statute when you prepared this report?
Yes, I did.
And where would you get a copy of that state statute?
Yeah. So even for probable cause, which is a higher standard than reasonable suspicion, cops can have a reasonable mistake of fact, and the one that always just irritates the living piss out of me, they could have a reasonable mistake of law. Now, why the Supreme Court lets cops have reasonable mistakes of law, especially considering the circumstance? It was like Hein, H-E-I-E-N versus North Carolina. The cop thought you had to have 2 functional brake lights. Well, according to the state statutes, you only have to have 1 functional brake light. So he pulled the dude over for only having 1 functional brake light. He pulled the dude over for literally complying with the state statute. And he found drugs of some sort or whatever. And so all of a sudden, it's a valid thing to do, because even though the cop was 100% wrong about the state statute, it was still probable cause. Like, so I just got to caution everybody, all these auditors, they all want to know, they all think they know, they all think they have game on when a cop has reasonable suspicion. You don't know what information the cop received prior to getting there. You don't know what the cop believes he saw or actually saw. You don't know shit about fuck. And the cop can lie to you. You will never know shit about fuck. You literally play a game all the time. Well, I mean, there are defenses to crime. So there's a difference between what cops do. If a cop makes a reasonable mistake of law, he arrests you. And then you get to go through the full trial to determine whether or not you broke the law. The cop isn't breaking the law by arresting you without probable cause. You could sue him. He's not going to get convicted of a crime. If you make a reasonable mistake of law, if you make a mistake that ends up in you committing a crime, well, ignorance of the law is no mistake. But if the cop has ignorance of a law and commits a crime, the cop is held to the same standard you are. If you make an arrest, you wouldn't have, if you were acting under color of state law and you make an arrest, but you're a private citizen, you could be sued under 1983, possibly. And if you get sued under 1983, possibly, as a citizen who's acting under color of state law, like let's say that you jump in to help a cop make an arrest, right? And you get sued personally for wrongful arrest and for 1983, yada, 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 right? The reasonable mistake of law from Hein would apply to you too. I've talked about this before. I think it's retarded. Taxpayers will continue to pay the price. You're just adding in a different fucking layer. You're adding in a different layer. A lot of cities and counties will pay the bill for the cops. A lot of cities and counties will do that. But the thing is that if the cops are carrying their own, you call it malpractice insurance, then that insurance is going to run up costs as soon as they get sued, and is going to have costs associated with it. And it's going to be something that the cop will have to be able to afford, and the cop will have to be able to afford it with his paycheck as a cop, which means paychecks for cops are going to have to increase to offset the cost of the insurance. You see where this is going? So it's just all you're doing is saying, instead of the cop paying for it, if the city paid for it, the taxpayers would pay the city would pay the legal fees and the whatever settlement. Instead, if the cop has to carry his own insurance, the taxpayers pay the city pays the cops pay the insurer pays the legal fees. It's still, the chain is still from the people. I understand that stupid people, and I don't mean any offense to you, writes on, but stupid people don't think this through, and they think, oh, the cop will just be paying out of pocket. But insurance, just like your car insurance, you could be the perfect cop. You're still paying car insurance, or you're still paying cop insurance, and if you have to use it, I just want to point this out. There are a lot of 1983 lawsuits filed all the time, everywhere. For the people who are filing informa pauperis, i.e. the people who are currently incarcerated, generally, there is a pre-screening that screens out a lot of them. There will be a clerk who's an attorney who works for the judge who will actually read these things and be like, yeah, we should grant for informa pauperis to you and not to this guy, and blah, 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 right? So there's a pre-screening. But most of these things are taken care of on the qualified immunity stage. And the qualified immunity stage still incurs costs. You still have to answer the lawsuit. You still have to do some initial kinds of things. You still have to prepare and argue a qualified immunity motion, a 12b6, to get it to go away. Attorneys can bill a lot. I'm cheap at $325 an hour. There's a lot of attorneys out there, $400, $500, $600 an hour. And insurance companies tend to use the more expensive attorneys. So, I mean, these things can get expensive fast, even if they're meritless. And as Mr. Metz can attest to, a lot of them are meritless. Well, Charbo, like, again, buddy, again, you're like, I hate to say this. Like, now I feel like I'm picking on a retard who's actually retarded, and that doesn't make me happy. The example of Hine with the tail light was a criminal case where the guy was going to jail. It wasn't a 1983 lawsuit. The motion that was pending in Hine, and I might be saying that wrong, was a motion to suppress the evidence that was discovered as a result of the stop, the drugs, etc. So this has absolutely nothing to do with qualified immunity. This is across the board. Anytime a cop stops you, he can make reasonable mistakes of fact and reasonable mistakes of law. And qualified immunity doesn't necessarily protect intentional bad.
Statute.
306 statute book.
Is that something maintained at the police department?
Correct.
And you reviewed it after the interaction with Mr. Gray.
I reviewed it several times before the interaction. But yes, to answer your question, after.
Well, so everybody thinks of a better way, but it's really hard to come up with a better way. The way is pretty good as we have it. Qualified immunity kicks out a lot of bad claims. Most of the claims that qualified immunity kicks out are bad. They're unfounded. Most of the claims. It does catch some that are where the right has not been established in that circuit. It does catch some of those, but those are the exceptions, not the rule. The rule is that if you have a good case, a 1983 lawsuit, then you're gonna profit from it. And I can tell you that is the rule, not the exception, but it's the rule, because attorneys take 1983 lawsuits all the time on contingency. If qualified immunity was as bad as the people in this community have been led to believe, attorneys wouldn't take these cases on contingency. But they do. So you have to think about that. No attorney is going to go out there and blow tens or hundreds of hours on a case just to have it washed away by qualified immunity if that was the rule and not the exception to the rule. Yes, cops can arrest you for anything at any time, basically, yes. That doesn't mean it's going to be a lawful arrest. That doesn't mean you can't sue them for it. That doesn't mean you can't sue them and win. You're retarded and you're pushing things to the extreme. I told you a basic example of what Hine was. But yeah, I mean, it's not good. It's certainly not good. It's not good. I really dislike Hine.
So let me rephrase that, just make sure we're saying the same thing. This wasn't the first time you had ever looked at that statute, but you reviewed it again after your interaction with Mr. Gray. And you can't, as we're sitting here today, articulate any of the elements of harassment.
Objection asked and answered.
Not off the top of my head, no.
When you go back to the justice of the peace, then it's no longer up to the police if there's PC for an arrest. The police don't determine if there's probable cause. I don't know how many times I have to tell this to you fucking crayon eaters. The police guess that there's probable cause. The judge determines if there was probable cause. The police don't know if they have probable cause when they make the arrest, just like you don't know. I don't know why this is hard for people to grasp. Probable cause may or may, it's like Schrodinger's cat, not the shitty fucking YouTube channel, but the cat that's in the box that you don't know if it's dead or alive. And it's in both states and neither state until you open the box, right? Probable cause is just like that. You don't know if the cop had it or didn't have it until there's a probable cause hearing or a grand jury indictment or whatever. You don't know. So it's not up to the cops, is really what I'm trying to say. It's not up to the cops.
When you were or had reasonable suspicion that Mr. Gray had committed the crime of harassment, what course of conduct Mr. Gray had or had reasonable suspicion of when you were or had reasonable suspicion of
What was the fucking question?
when you were or had reasonable suspicion of that Mr. Gray had committed the crime of
Objection assumes that he had reasonable suspicion. I don't know that he's qualified to make that determination. It calls for a legal conclusion. Did he have reasonable suspicion? Or are you asking him if he believes he had reasonable suspicion?
harassment. What course of conduct directed at a specific person were you aware of?
I'm not getting what you're saying.
Well, that's one of the elements of the crime.
Where was the objection? Why is this counsel, the defense counsel is fucking terrible.
To be guilty of
And just so you know, I know I've talked through a lot of this. The attorney who's asking the question, Jeff Gray's attorney, it's fine as the asking attorney to ask questions that should be objected to. It's fine. Like you know, you should be pushing the limits on what you can ask. It's a contested system. The defense attorney has to be involved, pushing back on your questions. If he's not pushing back, then you're just going to move it until he finally starts pushing back. So I'm not faulting Jeff Gray's attorney. Just so we're clear, Jeff Gray's attorney is doing fine. I don't really know what the fuck he's pushing for at this point. I don't really know or care. But the defense attorney, like I said, he needs to be taken out back and shot. He's too old for this line of work. He doesn't have the fire in his belly. He's not fighting back at all.
this crime that you cited in your report. There has to be a course of conduct directed at a specific person.
Okay.
What course of conduct directed at what specific person were you investigating?
Whatever statements the Waverly Police Department obtained from those victims.
But you had no knowledge.
Wait, what?
Well, that's one of the elements of the crime. To be guilty of this crime that you cited in your report, there has to be a course of conduct directed at a specific person.
Okay.
What course of conduct directed at what specific person were you investigating?
Whatever.
Well, again, you say, I don't know, because you say you don't know the elements, number one. But number two, if you just have a reasonable suspicion, that means reasonable suspicion that crime is afoot. Reasonable suspicion crime is afoot. Something's wrong. This shouldn't be happening and this shouldn't be happening. I think that there's a crime in progress. Using the facts that I can see and articulate and my knowledge and training as a cop, I think that there is a crime that is occurring. I may not know exactly what crime it is. It might be battery. It might be kidnapping. It might be assault with a deadly weapon. It might be robbery. I don't know. But I have reasonable suspicion, I think, I have reasonable suspicion based on these facts and my training that a crime or multiple crimes are happening. And now I get to investigate. I get to detain people if a court agrees with me that I had reasonable suspicion. But now in my head, at least, I'm justified to detain people to determine what, if any, crimes were committed. And then once I get to the point where I believe that a specific crime was probably committed and that you probably committed it, then I get to arrest you, in theory, assuming a court agrees with me. So you don't have to have reasonable suspicion of a specific crime. You may have to have probable cause for a specific crime, maybe. I think there are some states that might differ. Some states think you just have to have probable cause of the crime. Some states think you need to have probable cause of each element of a crime. So talk to a local attorney. But yeah.
There were statements the Waverly Police Department obtained from those victims.
But you had no knowledge of that.
I had knowledge.
Okay. Who was the specific person?
I can name them.
You had no knowledge of that. I had knowledge. So you had no knowledge of it. No, I had knowledge. And then he goes with, who's the specific person? Well, you didn't say you had knowledge of who a specific person was.
Well, where are they
Off the
named?
top of my head.
Where are they named? They're not in your report.
There are statements that should be in your file.
I don't have any statements.
I don't
What,
know.
have you seen those
I
statements?
have.
Well, let's pause. Do you have the statements?
Yeah, I got statements,
Have you produced them?
pretty sure.
Well, what would be the base numbers of those?
Oh, counsel's not producing disclosures. Oh, bad counsel, no cookie. Further reinforcing my opinion that this defense counsel is asleep at the wheel.
Read it. You should have my document production.
I do.
Well, then look through the document production. I mean, we've done disclosures. The time has not expired for us to do written discovery. You wanted to go into the deposition before you got all that. So here we are.
You're telling me that you have the reports now, and I'm asking you to help me identify them because I can't find them.
And I'm asking you to help me identify them because I can't find them. Well, I'm not the deponent. You could ask whatever the fuck you want, but I'm not helping you for shit. Put on your big boy pants. You're an attorney. You should know what the fuck's in your file.
Would it be contained
But also, probably should have been disclosed.
in a CAD detail report? What would these statements look like, Mr. JOFFRION?
I can't describe them, to be honest with you. Just statements.
Good old JOFFRION. I'm not fucking helping you.
Is there any specific form that they would come in?
It's just like Waverly Police Department statement.
I'm sure you produced the statements. In your disclosures.
Yeah. So right now they're talking about, I believe, they talked about vagrancy initially, but now he's saying that he had reasonable suspicion of the crime of harassment. So there you go. So they're not talking about vagrancy. I would agree with you that if vagrancy is not a crime, it would be difficult, if not impossible, to establish reasonable suspicion of a crime being afoot. But again, you're mistaking what you have to have reasonable suspicion of. You have to have reasonable suspicion that crime, this nebulous crime thing, is afoot. So you have to be able to articulate facts and say, based on my training and whatever, that crime, generally speaking, is afoot. You don't have to have reasonable suspicion that vagrancy is afoot. You have to have a reasonable suspicion that crime is afoot. And again, once you get into the probable cause area, then you have to be more specific about probable cause for a thing.
I'm willing to be corrected, but I don't know why I would have.
So I don't think anybody would ever say or should ever say, oh, I have reasonable suspicion of vagrancy. I mean, you might, but generally speaking, oh, we've got brick. Oh boy. And that's a face. All right, we'll do this.
What's
All
up,
right,
Merv?
Rick, what do you got for me?
What's good? What's good, brother, man? How you doing?
I'm not really into small talk. What do you got?
No, you don't have time for it. You don't have time to say hello.
What are you up here for?
I had some questions.
Ask a question.
So you said that you're not really understanding what everybody's interest is in this deposition, correct?
Really didn't sound like a question, but sure.
It's a yes or no. But yeah, no, I mean, if you don't want to have a conversation, I'm out of here, man.
You haven't asked a real question yet. Like, let's get to it. Let's get to it.
Bro, I'm not going to do this.
Okay.
There's one from Aaron Hustley. There's one from Julie Bromley.
What are the base numbers there?
I don't say base no longer. Did you use base numbers?
I mean, I don't have those reports unless, I mean, I don't think I have those. And I don't think that they were produced in the disclosures of the defendants.
Should have been produced. Well, so I've had a history with Brick, and I don't really care for him as a person. I don't care how he is. He doesn't care how I am. Like, and none of you are here to listen to 5 minutes of pleasantries. Let's get to the fucking point. If you can't get to the fucking point, generally speaking, that means that you don't have a point to get to. So just like, you can't come up here and just say like, hey man, I just wanted to say that like, this is the issue with it. Okay, great. Let's talk about that. Hey man, I had a question about what you were saying on probable cause. Sure. Let's get to it. Let's talk about it. Hey man, how's it going? What's up, buddy? Hey, how's the wife and kids? Oh, I heard you got a new dog. Like, no one fucking cares about that. I don't have time for it. I don't like you. I just want, let's just get to it.
Do you think that this might have come from that public records request from the other person?
I'm sure there's a part of that, yeah. There was a lot of documentation if I remember that production.
Yeah, that's fair enough. I didn't have anything to do with that. In fact, just FYI, that guy sent that stuff to me unsolicited. So I produced everything we had.
Yeah. Okay. So I normally an interview would have been about an hour, right? And we're well past an hour. We're at 2 hours into this, and I'm really running towards the end of my desire to deal with this. This isn't interesting. To the best of my knowledge, no one has presented me with a timestamp of where it does get interesting. So, like, I just don't like if you want to come up and you want to ask questions, like Charbo came up, asked questions. I don't think I was too fucking rude to him. I don't think I was. And I answered his questions. I actually answered his questions. I treated him like an adult, and I answered his questions. If Brick wants to come up and ask questions because he doesn't understand something, that's fine. He can do it. So one guy says you're disingenuous, but then Charbo says that they were cool. Like, oh, you're rude. Oh, well, why don't you go fucking cry about it? I love all the First Amendment auditor fans who just get so fucking butthurt about people being rude. Well, it's my First Amendment, bitch. Get used to it. And I'm probably only going to go for about another 15 minutes at most. So if you do have questions, you want to come up, ask them. I'll answer them probably. And we'll move on. Just don't like beat around the bush like you're playing coy, like you're trying to fucking hit me up for a date or some shit.
Report that you, all right. So this is within whatever the public records were produced by the city to a public records request generated by, what was that gentleman's name? He goes by Hattiesburg Civil Discourse. Joshua Hodge. So have you reviewed those statements from Ms.
So just so I understand, the city and or the defense counsel didn't turn over documents that he had because apparently they were produced in a records request to somebody who's not a party to this shit. Oh, defense counsel sucks ass. The city really needs to maybe think about hiring a different defense counsel for their attorneys. Well, so what you think are the highlights might not be what I think are the highlights. I don't know. We're 35 minutes into it. We might get another 5 to 10 minutes.
Ladner and others. I'm sorry. Yes.
Yes,
When did you review those?
whenever they were obtained. I'm not sure which date or time that they were obtained.
Clay is very ass mad right now.
Well, when were they obtained in relation to the writing of your report?
I'm not sure.
So you don't know if you saw them before or after the report. Did you see them before or after this videotape interaction with Mr. Gray?
I can't recall. It's been over a year ago.
You don't know if you saw the written statements of the witnesses before you got out of the cruiser and approached Mr. Gray.
I did not see the statements before then. No.
Okay. So at the
Put your phone away, counsel. Put your phone away. Pay attention to the questions. Oh, fucking hate it. Oh, what a shitty attorney.
time you were interacting with Mr. Gray, you were not aware of any conduct directed at a specific person.
Yes,
You had a report from Mr.
You were not aware of any conduct directed to specific. Yeah, so he wasn't aware. Okay.
Halsey, but you did not know the specific person's name.
I didn't know the specific person's name.
And were you aware of any credible threat asserted by Mr. Gray towards a person?
Negative.
And what was the course of conduct that was considered harassing to this person that we don't know?
Whatever they
If you're basing it off this deposition, you're dumb and you're wrong. Nothing in this deposition so far has been anything that would even remotely get him fired.
stated.
Clay's very ass mad in the comments.
But at the time, you were investigating Mr. Gray, demanding his identification for the reasonably articulable suspicion of the crime of harassment. You had no information about the course of conduct because you had not seen any of the reports.
Objection to the form.
What objection? What objection? Objection to the form? That's not a fucking objection.
Isn't that correct?
Repeat what you just said.
So I asked you about the course of conduct, and you said something like whatever they said. And we've already established that you had not seen any of the reports at the point that you were interacting with Mr. Gray. So how could you be investigating whatever they said when you didn't have that information?
Because he got relayed from Halsey that there was somebody who was peeping and harassing, etc. So again, like he's stupid. The cop is stupid for going out there and doing the investigation based on these statements from Halsey, but I'm sure they do it all the time. And sometimes there's merit to it. I'm sure sometimes the cop saying, hey, this is going on, I need you to do it, is a valid thing. In this case, it wasn't, but whatever. Poor Clay. Poor Clay.
Because of the complaint that came.
You know, it's weird. Brick and Clay. Brick and Clay. Isn't that crazy? Are you Brick, Clay? Are you Brick? Are you Brick, Clay?
And that was routed to you from Hersey. Was there any specific information provided by Chief Investigator Hersey about the conduct that would constitute harassment?
Would be Investigator Hersey. But he did not further explain. He just stated it was harassing, peeking through windows, so on and so forth.
Well, we got
Yeah, you get asked the same question multiple times to get the same answer. And this doofus isn't actually objecting to anything.
peeking through windows and harassment.
He doesn't look like I expected him to look. He doesn't look at all like I expected him to look.
That's all we've got at this point.
Harassing is a crime.
The elements of which you can't articulate now.
Not off the top of my head.
did you suspect or have any reasonably articulable suspicion that Mr. Gray had any sort
Objection calls for a legal conclusion. He would never know if he had reasonable articulable suspicion.
of weapon?
I have no idea.
I know that, but that wasn't my question. I'm not asking.
I absolutely fucking hate the cops who do the pat down. Just the cursory pat down. Hey, I'm going to talk to you for a minute. I'm going to pat you down. Fucking hate that, dude. Fucking hate that. I hope Jeff Gray got a lot of money out of this. If you got a pat down when the dude isn't even pretending he had reasonable suspicion. Oh, I fucking hate that.
You if you knew he did. I asked you if you had any reasonably articulable suspicion that he did.
I can't answer that. I don't know off the top of my head at that moment what was running through my head.
It's the original beef between who? Me and Brick? I don't fucking remember. I remember him vaguely as being really fucking stupid and persistent. And I remember a lot of Bible quotes, but maybe I'm wrong about that. But anyway, I have like just categories of people, and he's in one of the shit tier categories. Disingenuous actor, or too stupid to fucking know that he's being disingenuous.
It's not a crime to have a weapon.
I understand that.
Well, you don't actually have to say I don't consent to searches. A lot of times these cops just go up and they like fucking grab your pockets and shit. Like, you know, it's not like there's not a lot you could do about it except sue. And unfortunately, there's not a lot of damages there if all they did is grab your pockets. And like if they're patting you down for weapons, you know, your wallet doesn't feel like a weapon. And going into your wallet to pull out an ID card, obviously the ID card isn't a weapon. And I've seen them multiple times search people unlawfully for their ID under the pretext of a Terry frisk. And that's not the way it's supposed to happen. The problem is, how do you enforce that right? Well, you have to sue them for it, but there's not a lot of money there, unfortunately. There's so getting an attorney to do it, and you know, and it's really hard to say if the cop does have reasonable suspicion, again, because you just don't know what the cop knows or thinks he knows. But it's just frustrating for me to see cops just fucking start searching people at the drop of a hat. Like, and you could tell, like, some of these cops, that's just what they do every time, all the time. Every time I make a stop, bro, boy, howdy. If I'm talking to you, I'm just going to start grabbing your pockets. Hope you got a big dick in there. You know, it's just fucking irritating as shit. I don't like handsy cops.
But today, you're not able to say that at the time you interacted with Mr. Gray, you did or did not have a suspicion that he had a weapon.
We read that a little bit so I can better understand it.
Talk to a local attorney about that, Charbo.
Did you have any basis to believe that Mr. Gray had a weapon?
I would perceive that he would, just for my general safety and my fellow officers.
And I fucking hate the for my safety shit. Cops are almost as big of pussies as the DMCA lawyer is. And like all the fucking time, every time, for my safety, for officer safety, you know, we gotta tase the shit out of somebody for officer safety. We gotta go through all their pockets for officer safety. You know, we gotta have AR-15s and bulletproof vests, but you can't have them because of officer safety. Every fucking time, all the time. I get so sick of officer safety. Like, bro, your job is to take risks. Your job is to put in theory, should be to put yourself between the good people and the bad people, and if necessary, suck up the fucking bullets. And all this bullshit about officer safety, you get to inconvenience and harass every fucking buddy for officer fucking safety. Fuck you.
We treat anybody that they have access to a weapon.
Well, I assume every person is armed as well, but that's not the same thing as having a reason to believe that you are armed right now because I saw the firearm on your right hip.
Okay.
I'm not asking if you make the assumption or the default position is that people are armed. I understand that. I'm asking, did you have any reasonable belief that Mr. Gray was armed?
Objection calls for a legal conclusion. Now, normally, in depositions, once again, you can ask for legal conclusions in written discovery because the assumption there is that the lawyer is going to provide the legal conclusions in written discovery. And normally it's objectionable at depositions to ask for legal conclusions because the deponent isn't a lawyer and doesn't know the legal conclusions. It can't do it. In this case, Jeff Gray's attorney keeps asking this cop about reasonable suspicion. And once again, the cop won't know if he had reasonable suspicion unless and until a judge makes a ruling on it. So the attorney sitting there looking like a fucking idiot, squinting away. I just have zero respect for this guy. Zero respect for him.
Other than just the default that you're going to treat everyone as if they're armed until you prove otherwise.
I'm gonna stick with that answer. Treat everybody like they're armed.
So I'm going to assume, unless you tell me differently, that you didn't have any particular reason to believe that he was armed.
I didn't say that.
You did not say that either. So I'm going to move on. Now, what person or what evidence did you have to believe that Mr. Gray was stalking someone?
The report of it. The chief investigator has it.
The peeping through windows and harassing.
Same thing.
That's the same thing as stalking.
No, I did not say that. I said the same person that reported the stalking, same thing as I'm saying peeping Tom and stalking, harassing.
And yet we don't know who that person was
Who person? Which
that
person?
reported the peeping and the stalking.
To who?
You don't know who that person was.
To who?
To you or
It's shitty questions. Come on, attorney, spit it out. You don't know who the person was who reported it to Halsey, who then reported it to you, is really what he's asking.
Hersey.
Hersey, Halsey.
Never.
You also said that you were investigating Mr. Gray in your report for violation of
Do you want to
Raven
pat me
City
down
Ordinance
for weapons,
82-1
Michelle?
peddling. What constitutes the crime of peddling?
I can't think of it off the top of my head. I don't recall.
How could you be investigating Mr. Gray for peddling if you don't know what peddling is?
I knew what it was then.
Oh, these questions they're not going anywhere. They're not going anywhere. The questions aren't going anywhere.
But I'll have to refresh my memory.
What caused it to be fresh in your memory on May 30th, 2023 at approximately 9:46 a.m.
The answer to this is going to be I don't know.
that it's not fresh October 9, 2024? Did you?
I have no idea.
Close enough. Like, come on, dude. Like, what are we doing here? What are we doing here?
Your testimony is that on May 30th, 2023, you knew what the crime of peddling consisted of, correct?
Not a crime. City ordinance.
Whatever peddling may be, is committing that not a crime?
I'm not a lawyer.
Is committing that not a crime? Is committing that not a crime? Is peddling not a crime? Is that what he's trying to say?
Just a law enforcement officer.
But you wrote a report, Mr. JOFFRION, that said crime description peddling.
Right.
So according to your report, you were investigating Mr. Gray for peddling.
Stalking, harassing.
Well, it's both.
Yeah, correct.
What constitutes the elements of a violation of city ordinance number 38?
I have no idea. Not off the top of my head. I don't recall.
Did you know on May 30th, 2023?
I don't recall either where my mind was or what I was thinking.
Sergeant JOFFRION was advised that that there had been several complaints regarding him asking for money, parentheses, violation of city ordinance number 38, in paren, and harassing residents. And you have no idea what city ordinance 38 is.
I'll have to go back and look at it.
Boring.
Why did you describe Mr. Gray as argumentative?
Because he wouldn't provide identification.
Well, he had explained to you that he didn't believe he was obligated to provide you with identification under the circumstances, correct?
Correct.
And he said, what was his reason that he gave you why he didn't think that he had to provide you with identification?
That's your client. I'm not sure.
No, that's not what I asked. What was the reason that he gave you?
I'm not sure. I don't recall.
All right, let's go back to the video.
It's in the fucking video. You don't need to play the video. Like, why? Like, why are you asking him about what happened in the video? You have the video. You're wasting time. Why? Again, why is this interesting? This isn't interesting. I'm gonna jump because
You literally didn't care about Mr. Gray's constitutionally protected expressive activity?
No.
Was it Mr. complaint by the mayor of this city? My question for clarification is, when you said, I literally don't care, what did you literally not care about? We've already established that you told Mr. Gray that a citizen can't get body cam footage, and that's
the attorney's like done with this too. But you know, if you've been active and objecting, you would be so sleepy, Mr. Attorney.
not accurate. Why did you tell us that?
That's not what anybody says.
I don't recall.
What is your department's policy on review of body cam footage?
I don't recall.
How many times have you watched this video?
I don't recall.
Have you gone to Mr. Gray's YouTube channel?
Don't recall.
Have you read any of the comments on Mr. Gray's YouTube channel?
The attorney zoned out. So yes. Well, what do you mean clearly no? You could answer a question, I don't know, for a variety of reasons. And it could be that the question is somewhat unclear, etc. But yeah, you can definitely answer most questions, I don't know. The thing is that it can lead to, in theory, it can lead to issues with the jury thinking that you're not a truthful person. So if this goes to trial, and if he goes up on the stand, and if he gives a completely different answer on the stand, well, then the attorney, the deposition attorney, can be like, well, why didn't you know this then if you know it now? And the normal answer is, well, I refreshed my recollection, I read this, I did that, or whatever. But if it's too much, then all of a sudden the jury or the judge, whoever the finder of fact is, might start to be like, oh, so you were just being shitty, right? You were just lying. And if you're lying then, you're lying now. Let's post this. Let's post this so everybody can see that I got mad. I didn't get mad. I'm not interviewing him if he's not on camera. That's not mad. If he wants to be a bitch, he can be a bitch. I'm not going to be on camera. Okay.
Sergeant, let's take a few minute break. Let me go over my notes. I'm drawing to an end. I want to make sure I haven't missed anything. Okay. Sergeant, Jofferrion, we just got one area that I want to go back over. In this video, around the 2:20 mark.
Here's the issue with this DMCA attorney, right? He's on my Discord, and I know he's on there for the purposes of getting a little bit of exposure. Sure, fine. I'll shout him out. But you know what would also get him exposure? I don't know, maybe having an interview with me. That would get him some exposure. People would be able to get a feel for him. People get a feel like there are some people who gained a lot of trust in or lost a lot of trust in Kate Peter over my interview with her. People had experiences, good and bad, watching my interview with De Laguna, whatever. But the way people connect, generally speaking, on a video platform. Oh, he's mad. I called him a bitch and a pussy. Oh, is he crying or are you crying? Oh, poor thing. I use mean words. I'm too sorry. Go somewhere else if you want to hear mean words. But anyway, he wants the exposure, like literally the best way for him to get exposure. I mean, he has his picture on his LinkedIn, right? Or at least he has a picture on his LinkedIn. You know what? Let's look at it. Do I have it? I thought I had downloaded it. Sort by modified. There we go. Open with, choose another app. I'm gonna go with why can't I open it with choose an app on your PC? Yes. Give me the Google Chromes. Why do this? Why can't I just open it with Google Chrome? That way I can show it to you. And we're gonna go to downloads. How about that? There it is. If I do it this way, no. How about this? And then I could open image in a tab. Share this tab instead. This is him, right? Allegedly. But who knows how much of that is whatever, obviously he's scared of his chin or something. He's trying real hard to hide it or something. I don't know. Maybe he just had a big zit that day. But all I'm saying is that people connect better on a video platform when they can actually see the person they're talking to, right? That's the deal. And you can't really trust it because like he might download Shiz's avatar or Shiz's filter, right? He might be like 5,000 pounds. He might be 5,000 pounds. But if he has Shiz's avatar, he'll look like he's, $125. Anyway, so like I don't like to have non-people up on my channel. I want to have people up on my channel. And if he wants the exposure in a positive way, he could show up here and put his face where his mouth is, And if he doesn't want to do it, that's fine. He's an adult. He can show up or not show up. I mean, I'm not a big channel or anything, so he can show up or not show up. But it would be interesting. Don't you think people would want to hear two attorneys discussing the lawsuit he's got going on? Don't you think that would be interesting? Oh, that dude was so big that his face ate his nose. That was a big fucking dude. Anyway, I honestly don't know, and I really don't care. Like, I'm not gonna hunt him down, obviously. I don't give a shit. Like, if he wants to do it, he wants to do it. I thought I'd ask him some questions about some of the cases he's had in the past, and about his experience, and about his knowledge, and about this, and about that, and about the next thing. If he doesn't want to do it, he doesn't want to do it. But he doesn't want to do it because he's scared to show his face. He's scared to show his face. That's a bitch. He's got his full fucking name out there. He's got his photo up on his LinkedIn. He's scared to show his face. He also had some dumbass excuse like, I'm not really good on my feet. And who the fuck wants an attorney who's not good on their feet? First of all, people should know whether or not he's good on his feet before they hire him. So for all the auditors out there who are thinking about hiring somebody like him, maybe they want a good little preview. Maybe they do. So anyway, that's all I got for tonight. Sorry we didn't interview this loser, but what are you gonna do? What are you gonna do? I can't give him the intestinal fortitude to do it. He's got to figure out how to, if you start a fucking YouTube channel, I mean, unless you're gonna be one of those gay ass avatar people, unless you're gonna be one of those, then like sack up, sack the fuck up. Anyway, that's all I got for you today. Thanks for watching. Have a great day.